This is Democracy Watch. So, Mark, we've got a catastrophic ruling in the Eighth Circuit Court of Appeals as far as voting rights is concerned. So, first of all, can you briefly explain what happened here?
Sure. So the Voting Rights Act gets enforced two ways. The first is that the Department of Justice can bring lawsuits that say, hey, state, you're violating Section 2, for example, of the Voting Rights Act. We've talked a lot about these redistricting cases where districts were drawn in ways to disadvantage Black voters in, say, Alabama, and they were struck down under Section 2 of the Voting Rights Act. So the Department of Justice can bring those cases. But it is also the case since 1965 that the majority of those cases are actually brought not by the Department of Justice, but by private litigants. So it may be that the NAACP brings them, or groups of voters, or other civil rights organizations, that they are the private plaintiffs in those cases. And so what the Eighth Circuit Court of Appeals did for the first time by any court of appeals said that that only the Department of Justice can bring those claims. There is no what is referred to as private right of action. In other words, there's no right for private individuals or groups to challenge states and counties that violate the Voting Rights Act. Only the Department of Justice can.
Now, is there a way to appeal this ruling by the Eighth Circuit, or is this final in terms of how the Eighth Circuit will operate moving forward?
So there absolutely is an avenue for appeal. There are actually two ways that this opinion could get reviewed. The first is that the plaintiffs in that case could seek en banc review. What it's called is en banc, which means just a fancy word for all of the judges. Rather than a three-judge panel, they ask all of the judges on the Eighth Circuit to reconsider and rehear the case. The other is, of course, to ask the U.S. Supreme Court to hear the case and to review it. Those would be the two avenues to address this for the Eighth Circuit.
Is there any worry that if this thing does get appealed to the Supreme Court, that the Supreme Court could agree with the Eighth Circuit, and then it wouldn't just be the Eighth Circuit that's operating under this principle that there can be no private action, that it's every court of appeals that would have to abide by this idea that the only people who could bring Section 2 of the Voting Rights Act claims, for example, would be the DOJ?
Yeah, so this is a really important point, and I'm sure right now it's going through the minds of the lawyers who were involved in bringing this case. Do we limit this right now to the Eighth Circuit and just let it be? Or do we bring this up to the U.S. Supreme Court and potentially get a good ruling, but as you say, potentially get a bad ruling? And that is more complicated, Brian, because the Eighth Circuit encompasses only part of the country. It's Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. Now, that's not to minimize the impact in those states, but for example, for those people who've been reading Democracy Docket, you know that there is a case out of Louisiana that you and I have actually talked a lot about, that my firm's been litigating, involving redistricting. And in that case, just last week, the Fifth Circuit, very conservative circuit, held there is a private right of action. So actually found the opposite conclusion that the Eighth Circuit did, and that covers Texas, Louisiana, and Mississippi. So, you know, different courts will take different views on this. The Sixth Circuit has also previously held there is a private right of action. So the question is, do you have the Supreme Court resolve this, or do you live with, for now, the Eighth Circuit being an outlier?
Okay. And by the way, for anybody watching, Mark had mentioned Democracy Docket. If you're not yet signed up for Democracy Docket, it is the best outlet that I use for everything voting rights and elections. So I'll put the link right here on the screen. Doesn't cost you anything, but it's a great resource to follow in terms of all of this news. Mark, what will this mean in states covered by the Eighth Circuit moving forward? Like, how often does the DOJ bring Section 2 cases historically? Because not for nothing, but to what you alluded to at the top here, these Voting Rights Act cases are generally brought by your firm on behalf of private plaintiffs.
Yeah, so look, this is part of why this is such a potential calamity for democracy in this country. Because over the past 40 years, just to quantify this, over the past 40 years, there have been at least 182 successful Section 2 cases. Only 15 were brought solely by the Attorney General. And, you know, even under the best of circumstances, I mean, forget about what a Department of Justice run by Donald Trump would do, which is presumably bring no cases.
Correct.
But even under the best of circumstances, the Department of Justice has few resources relative to private firms to be able to bring these cases.
Well, to that exact point, are you concerned at all that the DOJ may not have not only the resources, but the attention to devote to all of the Section 2 cases that need to be brought to protect voting rights?
I'm very worried about that. I'm very worried about that because, look, as you say, the Department of Justice has a lot on its plate. The voting rights section of the Department of Justice is small. Even after it was significantly increased by Attorney General Merrick Garland, it is small. And they tend to want to bring cases that are very, very clear winners. The Department of Justice, when they bring a lawsuit, they are bringing it in the power of in the name of the United States government, using the full resources of the federal government. And therefore, they hold themselves appropriately to a higher standard. Whereas private parties have the ability to be a little bit more nimble, also to bring more resources and more people to the table. And that, I think, has borne itself out over time, where you oftentimes see the private plaintiffs, whether it's represented by my firm or by other organizations, like in the Alabama case, like in the Louisiana case, like in the Georgia case, all of those brought by my firm and other private parties, because we're able to, as you say, muster the resources, but also the attention and the risk tolerance to bring those cases. Thankfully, all of those have been successful.
Well, if this is upheld and there is a case within the Eighth Circuit that needs to be litigated, is it possible the DOJ could contract to outside law firms like yours so that you're still like a government entity in some type of way, so that you could bring about these cases?
Look, there is going to have to be some creative solution to this problem if the Eighth Circuit ruling stands, and certainly if it spreads. It is clear that Congress right now, because of Republican obstructionism, is not going to clarify the law. The easiest thing would be just clarify the law that there's a private right of action. The second possibility would be dedicate a lot more resources to the Department of Justice so that whether it is contracting with outside law firms or hiring more lawyers, they could bring more cases. But Brian, you and I have talked about this before. The Republicans want this statute to fail. Yeah. The Republicans don't want this to be enforced. So it's going to be very, very difficult to see any of those things happen unless we have a Democratic-controlled Congress and President Biden back in the White House.
Now, just more broadly speaking here, how can the Eighth Circuit claim that private groups and individuals don't have standing to sue if they are quite literally the ones being harmed by unfair maps and by diluted representation?
Look, this decision, I think, has to be viewed as part of the long-term effort by the Leonard Leos, the Federalist Societies, the constellation of right-wing groups to try to strip voting rights protections from the law. We've talked on previous episodes about the independent state legislature theory, which we called a fringe theory, and it went to the US Supreme Court and it was shot down. Well, what was the point of that, right? The point of that was to strip the courts from being able to protect voters and democracy. And so you have to understand this decision as part of that overarching narrative. Now, how could the Eighth Circuit buy into it? It's a very conservative circuit. Two of the judges that decided this case, are very conservative judges. Actually, the third who dissented is a fairly conservative judge. So, they're going to take their shots and try to find favorable forums. And, I could ask the same question about several of the anti-choice rulings that we've seen in Texas.
Yeah.
Right? How can courts do this? It's a shame that they do. We just have to hope that the Supreme Court sorts it out.
Now, you'd mentioned the Fifth Circuit before, which, again, you also mentioned is very conservative. They held that there is that private right of action under Section 2. So how do you reconcile completely opposite precedents in federal court? Like, the federal law can't just be interpreted in polar opposite directions based on the jurisdiction, can it?
Well, so it actually is, right? So if you are within the Fifth Circuit opinion controls for the courts in the Fifth Circuit. If you're in the Eighth Circuit and you're in trial court, you're bound by the Eighth Circuit. That's how the system works. The Supreme Court decides what are called circuit splits when the circuits are in different places. But I don't want to gloss over this point. The Fifth Circuit is oftentimes thought of as the most extremely conservative circuit. And even they found a private right of action.
Yeah.
Like, this is not something that should be very controversial. To find that there is no private right of action, you literally have to say that the US Supreme Court, in the case they decided last term in Allen v. Milligan, missed the fact that it was brought by private plaintiffs. You have to assume that the Supreme Court over and over and over again, in the dozens and dozens of cases that they've heard and decided involving Section 2, that in all of those cases, the liberal and conservative justices all just somehow missed something that these two judges in the Eighth Circuit all of a sudden found.
Yeah. All right. Well, finally, can you talk about the implications of Donald Trump being president? You spoke, and you alluded to this a little bit earlier, but of Donald Trump becoming president as far as Section 2 of the Voting Rights Act is concerned.
Look, we have seen a mission by the Republican Party under Donald Trump to eviscerate free and fair elections. I don't say that lightly. I don't say that hyperbolically. They are trying to undermine and undermine free and fair elections and to do everything possible to allow them to cheat. And one of the ways an authoritarian does that, one of the ways someone like a Donald Trump does that, is he undermines the basic protections afforded voters. So all of these things are of one piece. His constant lies about the 2020 election, the effort to get states led by Texas, but joined by a whole bunch of others and by 120 some odd Republican members of the House to try to throw out the election results in December of 2020, led, by the way, by Mike Johnson, the now Speaker of the House. That all of that, which led to January 6th, that then, as you recall, led to mass voter suppression laws in states like Georgia and Texas, and then the independent state legislature theory. And now this, Donald Trump is fueling symbiotically with the Federalist Society and the enablers of Trumpism to make the American democratic experiment fail. And it is thanks to people like you and the work that my lawyers and Democracy Docket do every day to try to prevent that from happening. But make no mistake, Donald Trump in the White House will be a catastrophe for democracy.
Well, we'll leave it there. Obviously, you'd mentioned the work that you and your team do. That work can't be overstated. So for anybody watching right now, if you want to support Marc and his team, please make sure to sign up for Democracy Docket. Again, it's that free news outlet Marc founded to focus on everything voting in elections. The link is right here on the screen. It's also in the post description of this video. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.